Blackledge v. Perry, Supreme Court, 1974. Justice Stewart delivered the opinion of the court. Perry was an inmate in a North Carolina prison where he got into a fight with another inmate. Perry is charged with a misdemeanor assault with a deadly weapon. After he was convicted by a lower trial court, he exercised his statutory right to appeal his conviction and seek trial de novo before a higher court. While that appeal was pending, the prosecutor obtained an indictment charging Perry with felony assault with intent to kill. Perry claimed vindictive prosecution. Perry urges that the indictment on the felony charge constituted a penalty for his exercising his statutory right to appeal, and thus contravened the Due Process Clause of the 14th Amendment. Perry's due process arguments are derived substantially from North Carolina v. Pierce and its progeny. In Pierce, the court considered the constitutional problems presented when, following a successful appeal and re-conviction, a criminal defendant was subjected to a greater punishment than that imposed at the first trial. While we conclude that such a harsher sentence was not absolutely precluded by either the Double Jeopardy or Due Process Clause, we emphasized that imposition of a penalty upon the defendant for having successfully pursued a statutory right of appeal or collateral remedy would be a violation of due process of law. Because vindictiveness against a defendant for having successfully attacked his first conviction must play no part in the sentence he receives after a new trial, we held that an increased sentence could not be imposed upon retrial unless the sentencing judge placed certain specified findings on the record. The Due Process Clause is not offended by all possibilities of increased punishment upon retrial after appeal, but only by those that pose a realistic likelihood of vindictiveness. The question is whether the opportunities for vindictiveness in this situation are such as impel the conclusion that due process of law requires a rule analogous to that of the Pierce case. We conclude that the answer must be in the affirmative. A prosecutor clearly has considerable stake in discouraging convicted misdemeanants from appealing and thus obtaining a trial de novo in the Superior Court, since such an appeal will clearly require increased expenditures of prosecutorial resources before the defendant's conviction becomes final, and may even result in a formally convicted defendant going free. And if the prosecutor has the means readily at hand to discourage such appeals by upping the ante through a felony indictment, whenever a convicted misdemeanant pursues his statutory appellate remedy, the state can ensure that only the most hardy defendants will brave the hazards of a de novo trial. There is, of course, no evidence that the prosecutor in this case acted in bad faith or maliciously in seeking a felony indictment against Perry. The rationale of our judgment in the Pierce case, however, was not grounded upon the proposition that actual retaliatory motivation must inevitably exist. Rather, we emphasize that since the fear of such vindictiveness may unconstitutionally deter a defendant's exercise of the right to appeal or collaterally attack his first conviction, due process also requires that a defendant be free of apprehension of such retaliatory motivation on the part of the sentencing judge. We think it clear that the same considerations apply here. A person convicted of an offense is entitled to pursue his statutory right to a trial de novo without apprehension that the state will retaliate by substituting a more serious charge for the original one, thus subjecting him to a significantly increased potential period of incarceration. Due process of law requires that such a potential for vindictiveness must not enter into North Carolina's two-tiered appellate process. We hold, therefore, that it was not constitutionally permissible for the state to respond to Perry's invocation of his statutory right to appeal by bringing a more serious charge against him prior to the trial de novo.